Welcome. Welcome to A Taste of Justice. I'm Professor Angela Mae Kupenda. This series is for all of us to learn more about the Constitution. This series is also for my students who are studying, who are taking First Amendment remotely this semester, to give them an added review or introduction to some of the materials we are covering. So let's get right to it. But before we do, I just want to say this, that the First Amendment is a very short amendment, but there are many court cases interpreting the First Amendment. All explanations here are my own and are not to be ascribed to my school or my students. For information purposes, I will tell you I'm a professor of law at Mississippi College School of Law, and I've been teaching for about 30 years now in law schools and in business school. Now let's get right to it. Now, today we had a very good discussion in class about unprotected categories of speech. Remember the general rule. The general rule is that pure speech is protected from content regulation by the government unless the government meets a very high level of review. Government must have a compelling governmental interest, and its regulation of the speech must be narrowly tailored to that interest. Unless, you knew it was coming, unless the speech is in an unprotected category. If the speech is in an unprotected category, government may regulate it, if it chooses, more freely. All government has to meet is a low level of review called rational basis. So we've been looking at some categories of unprotected speech. We've considered speech that advocates illegal action. Remember the modern day Brandenburg test. We considered obscenity. Remember the Miller test. And we've talked about defamation, where the case New York Times versus Sullivan becomes very important. Today, we are going to look at the fourth traditional category of unprotected speech, and that category is called fighting words. So I want to tell you, we're going to look at maybe 5 cases today. For my students, this will be a bit of a review for them. Let me just tell you, my students are coming along very well in the First Amendment class. They're learning so much. Later in the semester, after they take a lengthy examination, they will write position statements on current First Amendment conflicts. And there are so many out there. I'm sure we're going to have very good discussion and debate as they use what they've learned to support their positions and to consider opposite positions of their own. For now, let's look at the basic cases about fighting words. Now, a main case about fighting words is called Chaplinsky versus New Hampshire. And I've noted the name and the date at the bottom so you can Google it and read more about it for yourself. So in Chaplinsky, what happened? So a Jehovah's Witness was on public property on the street, making a speech denouncing organized religion. And the Jehovah's Witness said that a police officer approached him and didn't like what he was saying and cursed him. And then, according to the Jehovah's Witness, he then cursed the officer back, but only after he was provoked. Now, there is some disagreement about all of this in the record. The law that, well, let's go on to say that Jehovah's Witness was arrested. The law said you can be convicted for violating a state law forbidding anyone to address any offensive, deriding, or annoying word to another who is lawfully in a public place. Now, you're probably saying if the officer cursed him too, then they both should have been charged under the law. But that is not what happened here. Only the Jehovah Witness was charged under this law, not the police officer who allegedly also cursed or cursed first the Jehovah's Witness. So here the Jehovah's Witness was convicted, was charged and convicted. And now on appeal, the speaker, the Jehovah's Witness, who is the speaker here, he says that, wait a minute, this conviction is in violation of my First Amendment rights under the Constitution. And so he argues that his speech is protected. Now, what do you think the court held? This was a 1942 case. Did the court say, you're right, you're entitled to the right of speech, your speech is protected? No, that is not what the court held. The court said his speech was unprotected. Now, the court said that his speech fell in an unprotected category that government could regulate with a low showing if government chose to. The court called this category fighting words, fighting words. And this is how the court described fighting words. Fighting words are such words that would, as ordinary men know, cause a fight. Let me read that to you again. Fighting words are such words that would, as ordinary men know, cause a fight. Now, we talked about this in class. Why did the court said words that would make an ordinary man fight? Do men fight more quickly than women or less quickly than women? Or maybe the court was just using the word man and included men and women. And then we discussed, why did the court said fighting words are words that would make an ordinary man fight? Are we not called to be more than ordinary? Do we not have to learn how to have more self-control? But the court said here that those words that could make an ordinary man fight are fighting words and are unprotected. And so here, the conviction would stand. Now, we compared that case to another case. We compared the case to Terminello. Now, I didn't give you all the words that were said or allegedly said in the Chaplinsky case, not all of the curse words. You can Google that case and you can read the language for yourself. Okay, now let's go to this case called Terminello. Terminello, listen to this fact pattern and tell me if it is a bit different from Chaplinsky. So in Terminello, there is a group holding an event inside an auditorium, and they invite Terminello to be the speaker. So he is an invited guest to give his speech. And so he comes and he's giving his speech and he is talking about certain political and racial groups. And he's calling some of them by, I'm trying to see, is this the name where he was calling some of them scums and what have you? Yes, He's calling some of them scums and slimy and bed bugs and other bad things. So now, and people sitting there listening, they're enjoying his speech. But there is a group of people who are upset that he was invited to speak. So they are outside the auditorium, not inside. And they don't like the idea that he is inside speaking. And they want him to stop. So they're outside and they start throwing things through the windows, breaking the windows. And there are some people who are trying to get inside to hear the speech. And this crowd of people who don't like the speaker, they're tearing the clothes off people who are trying to get inside so they won't go inside to hear the speech that they want to hear. So was the speaker's words fighting words and unprotected under the Constitution? And did the government arrest the speaker, or did the government also arrest the individuals who were outside throwing things through the window and tearing clothes off people so they wouldn't go inside? Well, all we can see from the record is that the speaker was the one who was arrested. Some people label this case as the case about a heckler's veto, that people outside can heckle and therefore those inside cannot hear what they want to hear. But what did the court hold? Now, let me tell you, the court did hold in favor of the speaker, but it was a 5 in favor of the speaker, 4 opposed. It was a close opinion at the Supreme Court. 5, the speech is protected. 4, it is not. The 4 that said it is not, they said that he was inciting a riot in those who didn't want him to talk, those who were outside. But the majority said that Terminella was different from the Chaplinsky case. And so what do you think? Are they really that different, where Terminella's speech was protected and Chaplinsky's speech was not protected? Okay, let me give you 2 more cases. So the case Finer is a 1951 case. And Finer was, and you can Google and learn a lot about him, he was a white man, a Polish immigrant, a college student, and he was standing on a public street corner in a predominantly Black neighborhood. Actually, he was standing on a large wooden box. Have you ever heard people say, I'm standing on my soapbox? He was actually standing on a large wooden box giving a speech. Now, Finer's audience was about 80 Black and white people were gathered around listening to him. And this was in 1951. Finer, according to the court, his speech, he was encouraging people. Let me read what the court said. He gave the impression that he was endeavoring to arouse the Negro people against the whites to rise up in arms and fight for equal rights. That's what one of the justices said. Finer, he had called the president at that time in 1951, he called the president a bum, and he called the mayor of the city a champagne sipping bum. And he was encouraging people there, the people who were listening, to go to a meeting that night, a meeting of progressives to talk about racial equality. So one person who was listening, the police testified that one person got mad, really mad. And that person said, if you don't remove him, I'm going to fight him. So the question becomes, who would be arrested? The speaker, finer, or the person who is threatening to do bodily harm? Well, the speaker was the one arrested, not the one who made the threat to do bodily harm. Now, Finer argued that his speech was protected, but the majority on the court said it was unprotected speech. So government can regulate it more. And you can read about him in this case. He continued, even after his conviction, he continued to speak for civil liberties and for racial justice. But we want to compare the Finer case to a case called Edwards. And we compared this because the court in Edwards ruled in favor of the speakers and said that the Edwards case was a far cry from Finer, a far cry from it, way different. And I want to ask you, what do you think? So Edwards. Now, Finer was in 1951. Edwards is in 1963. And you know, in the 60s, there were lots of marches and protests for racial justice. So there's a group of young people, college and high school. And you know, young people were very involved, including even younger, in the movement for racial equality. They had met at a church, which was also not very unusual for the marchers to meet at the church to talk about what the approach would be and what the strategy would be. So they met at a church and they had a statement of their requests, their petitions to present, and they headed off marching toward the South Carolina State House. Now there were about 200 protesters, and the police knew they were coming, and there were about 30 police officers, and there were about 200 people, 200 to 300 people, onlookers standing around who were watching the protest. Now, the record in this case is quite interesting. Here are some of the things that the judge wanted to know. He wanted to know if the marchers were dressed nicely. Yes. And the police testified, yes, they were. They were dressed very nicely. If you look at some of the documentaries of the civil rights movement, you will see that the protesters were with dress, it appears, in their Sunday best when they went out to march for racial equality. The judge also wanted to know, did they block people who wanted to get by them on the sidewalk? The police said, no, they did not. They walked, they were orderly. They walked in single file and sometimes 2 by 2. And the judge said, did they follow police instructions? The police said, yes, they followed instructions. They were respectful. The judge, were they saying anything, right? Were they saying anything? And the police said they were singing. They sang the Star-Spangled Banner. And they also were singing various church songs. But look, one of the judges was a little annoyed, and he said they were clapping and they were singing in a boisterous, lively way. It was just like anything could happen any minute. Now, the court ended up holding that this speech was protected speech. And the court said this case is a far cry from the situation with Finer. But one of the justices who disagreed with the holding said they were out there with all that loud singing going on and clapping their hands and all of that stuff. Anything could have happened. That's why they had to be arrested. But the majority said this speech was protected. But now you're saying, what's that test about fighting words again? Oh, wow. How do you apply that test? So you see these cases. So First Amendment, it becomes a fairly case-specific type of analysis. So we have these two cases. Finer, he is arrested, a sole person out there on the street corner. The protesters here, however, they're arrested too, but the court overturns their conviction and says their speech is protected speech. Now, maybe the different speakers, different responses, different times. One was in the 50s, the other in the early 60s when nonviolent protest was happening. And you do know that during many of the nonviolent protests, there would be violence directed against the individuals who were protesting peacefully. But let's go on. Now, our final case that we're going to look at is the Cohen case. And you may have heard of this case before. This is the case where the young man has on a jacket, and on the back of the jacket is some writing. On the back of the jacket are the words F, the jacket. Now, the F four-letter word is spelled out. You can read the opinion yourself and see it in print, but F, that word, F, the draft. Now, this case is Cohen versus California. It's a 1971 case. And it was during the Vietnam War, the Vietnam conflict. You may not be aware of a mandatory draft, depending on your age, my viewers, your age, but there was a mandatory draft. And if your number comes up, whether you agreed with the war or not, then you would have to report. Some people would get excuses, but many people did not. So here the draft had become quite controversial for the Vietnam conflict. And so this speaker wore this jacket. He wore this jacket to the courtroom. He went in the courtroom with his jacket, F the draft. And there was a proceeding going on. One of the officers saw him with the jacket and went up to the judge in the courtroom and wanted the judge to order Cohen be arrested. But the judge said, get on away from here. No, I'm busy here. I'm not worried about that. I'm working on a case here. So Cohen took his jacket off and he laid it over his arm and stood there quietly in the courtroom. And later on, he left. When he went out in the hallway, the same police officer stopped him and had him arrested. He was arrested and he was charged, and now Cohen is appealing his conviction. He says, how are you going to convict me for speech? This was my right of free speech to state my position about the draft. I just decided to state it by using my jacket. So this case is such an interesting case because it goes through many of the things we've been talking about since we began this series on the First Amendment. So the first thing is his wearing the jacket. When you select your outfit each day, is that speech or is that pure conduct? And why does it matter? We had a great discussion on this, and the court even disagreed on this point. But if it's pure conduct, It is not protected under the First Amendment. The court said, oh no, every time you pick an outfit, it may not be speech, but here, he selected this because of the message it conveyed. And it's a message that others will understand. So therefore, this is speech, not conduct. Okay? The government said, okay, we have a different argument. The government said, this wasn't about suppressing the content of his speech. We have to have a certain decorum. We have to have a certain dress code in the courtroom. And it's not about his message, it's about the dress code. And the court said, now we don't buy that. This was not a content neutral, reasonable time, place, and manner regulation about decorum. You arrested him because of his message. The government said, well, we have another argument. The government said his speech must be punished because there were children present and there were non-consenting adults who didn't want to see this message. And the court said, we don't buy that, because the only person that indicated any problem with the jacket is the police officer, not a parent with a child or not a non-consenting adult in the courtroom. The government said, okay, even if it is pure speech, yes, pure speech is protected from content regulation, unless the speech is in an unprotected category, okay? And the government said this speech is speech that advocates illegal action, is trying to get people not to enlist in the draft. And the court said, we don't see how you get there. If the draft does express some disdain with the draft, but there's no indication that he was trying to keep people directly from signing up. There's no indication it satisfies the Brandenburg test. Remember that one? The modern day test for speech that advocates illegal action. The government said, okay, we have another argument. This jacket says F the draft. That is an obscene word. It is obscene. This is obscenity. As a result, it's unprotected. The court said obscenity is measured under the Miller test. You all remember that one? The Miller test. And for it to be obscene, it must appeal to one's prurient interest in sexual conduct. And the court said, we don't think this is going to be some psychic stimulation to a prurient sexual interest after draft. And so the court said, therefore, it is not obscene. Okay? And finally, the government said, it's fighting words. This could cause an ordinary person to fight. And the court didn't buy that argument either. It said, he didn't direct this insult or comment at any person. He didn't take his jacket off and shake it in someone's face or do something more. He just had the jacket on. Then the court gives a statement that says one man's vulgarity is another one's lyrics. I think that's an interesting quote. One man's vulgarity is another's lyrics. So here the court said, this is pure speech. It is not in an unprotected category. Therefore, government must meet the high level, compelling governmental interest, narrowly tailored to that interest. The court said that the government did not prove this, so therefore Cohen's conviction would not stand. The court struck that down, that he would go free. His speech was protected. So what do you think? Several justices dissented, meaning they disagreed. They thought the conviction should stand. One who disagreed was Justice Black. Now, Justice Black was very much a free speech judge. Why would he dissent? Justice Black and several other justices, they said, look, this conviction should stand. This is not even about speech. This is about pure conduct, and pure conduct is unprotected under the First Amendment. So that was the dissent. The majority in Cohen versus California said that his wearing of the jacket with F the draft in that courtroom was constitutionally protected speech. What do you think? What do you think about these fighting words cases? What do you think about the test and the application of the test? And what do you think about the Cohen case and whether the wearing of a jacket with a certain message should be protected speech? You think about it. Remember, learning is a key to enlightenment, and enlightenment to freedom, and freedom to justice, or at least a taste of justice. Subscribe and sign up for notifications. You don't want to miss a thing. Thank you, and bye.